Good morning, everyone, and thank you for joining us this morning for the second webinar that EML have hosted to discuss the reforms on the New South Wales workers' compensation legislation. We held the first of these events back on the 23rd of May, which was shortly after the exposure draft bill had been released, and there was a hearing in the Legislative Council's Law and Justice Committee. And at that time, for those of you who dialed in then, we were preparing for the potential that these reforms would become effective on the 1st of July 2025. But the process has, let's say, it's been a long road. We've had 3 hearings by the Public Accountability and Works Committee, and we saw some twists and turns in the parliamentary process. But here we are now in the 3rd week of November, and finally we have some certainty as to what the future looks like for the New South Wales Workers' Compensation Scheme. We're thrilled to have over 2,000 of EML's customers and partners register for today's webinar, where we will provide an overview of the most significant elements of the Workers' Compensation Legislation Amendment Bill 2025. My name is Katie Giddins, and I'm joined by my colleague, Matthew Vickers. We are General Managers at EML, and together we oversee the nominal insurer portfolio here in New South Wales. EML is appointed by iCare to manage workers' compensation claims, and with a team of 1,400 people across the state, we manage more than half of all open claims in the nominal insurer scheme. Our role and our purpose is quite simple: to help people get their lives back after a workplace injury. We do this by working closely with all stakeholders involved in supporting an injured worker's recovery and return to work. This reform package that we'll talk to you about today will be the most significant change to the New South Wales workers' compensation legislations that we've seen in nearly 15 years. The changes will certainly impact how we manage claims, especially primary psychological injury claims, but they will also have an impact on what happens in your workplaces. And we feel it's important that you understand those impacts and are prepared to adjust your internal policies, processes and procedures so that you can best support your workers. This is just the second webinar that we'll provide on this topic. We'll provide further sessions over the coming months, especially as more information on how and when these reforms will take effect, so that you, our customers, are as well prepared for the change as possible. Today, we'll cover 3 areas. First, a brief overview of the activity that has occurred since March, when news first broke of the potential reform, right through to the 18th of November, when the lower house of the New South Wales Government passed the Workers' Compensation Legislation Amendment Bill. And we'll share some insights into the second bill that was tabled later this week and is expected to be debated in the upper house next week. Then we'll go over what those major changes are that we expect as a result of the bill. And finally, we'll speak about what comes next. While you've probably heard about some of these changes that specifically affect psychological injury claims, there's been lots of coverage of it through the media, there are a number of other changes that will impact all claims, such as a new excess that will be payable by employers, PIAWE indexation, and changes to treatment approval thresholds. What's important to remember is that we don't yet know when these reforms will be effective. We await further information from the government on that, and we might guess, but we certainly wouldn't want to give you any assurances of what we think that could be. And even though we have a bill today, we still have many questions ourselves, and no doubt you'll have plenty of questions as well, particularly about how some of these changes will be implemented. Today, we will do our best to address your questions, so please use the Q&A feature to share them. If we can answer today, we will. If not, we'll take those questions on notice and provide responses as more information becomes available, either via an email update or in our next webinar. And please don't worry, if your question doesn't appear to be published live, our team behind the scenes is capturing everything.
Thank you, Katie. I think in terms of a timeline, from a pure legislative reform process, the process has largely been undertaken in an 8-month period to date, but it remains ongoing. However, the genesis for the need for change, at least as it relates to psychological injury provisions, was really driven by 3 common law decisions that ultimately altered the intent of the statute during the last decade. We saw Heggie versus Northern New South Wales Local Area Health Network in 2013, Hamad and Q Catering in 2017, and McHughes and Brewarrina Local Aboriginal Land Council in 2018. These 3 cases introduced the concept of perception of the employee and removed the long-held standard that the injury or illness was required to be wholly related from the actions of the employer. It introduced this concept known as the eggshell skull rule to workers' compensation, that as an employer, you took the worker as you found them, that you're fully liable for the harm, even if most people would not have sustained injury or illness under the same circumstances. Now, amendments to workers' compensation legislation are often emotive matters. It was definitely no different in 2025. The exposure draft of the proposed reforms was referred to the Legislative Council or Upper House Law and Justice Committee. The bill, once it was introduced and passed by the Legislative Assembly or Lower House, was then referred to the Public Accountability and Works Committee, who held multiple hearings between June and October and published their report earlier this month. The bill was then debated in the Upper House last Thursday and into the early hours of Friday morning, where an amended bill was passed and returned to the Lower House. On Tuesday afternoon this week, the Lower House passed the amendments and the bill awaits assent and the commencement provisions from government. However, at the same time, we've seen a second bill that was introduced in the Lower House in August. It was debated by the Lower House on Wednesday this week. The intent of this further bill is to address matters that were not passed within the first bill. In particular, the permanent impairment threshold for various forms of benefits for psychological injury claims that would continue beyond 130 weeks. In terms of our approach to discussing the changes contained within the bill as passed by both houses, we'll start with those that impact all claims and then narrow into the changes for psychological injury claims. I appreciate that in addition to clients of our nominal insurer operations, we're also joined today by some of our Treasury Managed Fund and self-insurance clients. Where possible, we've tried to footnote where those proposed changes may have different application or indeed may not apply. And I'd encourage you to stay in contact with the key contacts that you have at EML where you may have concern about its relevance for you. The first change to highlight is that of claims excess. This is really a case of going back to the future. Prior to 2006, an employer was required to fund a claim excess of the first $500 of weekly benefits paid. In 2006, the excess changed to reflect the value of the first week of weekly benefits paid. However, as an incentive to improve the delay in reporting claims, the excess was waived if the claim was reported within 7 days of the employer being made aware of the injury. Now, that change had the desired effect. The average reporting delay halved from 12 days at its commencement to 6 days by 2008. So this change seeks to return claim excess to that pre-2006 world, but it intends to increase the value of that excess paid by the employer to reflect the first 2 weeks of weekly benefits. Now, the 2 weeks itself was not specified within the bill, but it was specifically called out by the Treasurer when delivering the second reading speech in the Upper House before the bill was debated last Thursday. Now, most obvious question that I would have as an employer is what this means for cost of claims as it relates to premium calculation. Now, this is not clear, as it need to be determined by the insurer, iCare in the case of the nominal insurer, and advised within their market premium practice guidelines, or MPPG. We love an acronym in workers' comp, and they're filing to CIRA. But if we were to look at pre-2006 as a guide, that excess amount was deducted from the cost of claims that are utilised for premium calculation purposes. And I think it would be a reasonable expectation that that is what would occur when this change is enacted. The next change is a sensible modernisation of weekly benefit indexation provisions. Prior to the 2012 amendments, workers who received greater than 26 weeks of weekly benefits saw their entitlement reduced to an amount akin to a social security benefit. This still applies today to emergency services workers. And for those who are interested, the current rate for an individual with no dependent wife or children is $612.60 per week gross. Now, as with social security benefits, this amount is indexed twice a year in April and October. When we saw the 2012 amendments, we moved to a more modern PIAWE or pre-injury average weekly earnings method of determining weekly benefits, and a worker received a proportion of this amount throughout the life of their claim. 95% of that amount for the first 13 weeks and 80% for every week that they had an entitlement thereafter. But at that time, the indexation provisions didn't change, and this saw the PIAWE indexed twice per year, which is out of step with how pre-injury wages are generally increased, which for most of us is through an annual review. This change will see indexation occur once per year in April, bringing it in line with standard remuneration review processes. But I think the greatest benefit in this one, aside from that, is the reduced administrative burden on employers and insurers alike in terms of the wage reimbursement process and making sure that benefits are paid in accordance with the Act.
So this next change is one that has flown relatively under the radar, but in our view, it's actually one of the largest changes that will have the broadest impact as it affects all claims. We're talking about treatment approvals. Under the current legislation, we are required to approve treatment for an injured worker if that treatment is considered reasonably necessary. This bill changes that test slightly, but importantly, to require treatment to be both reasonable and necessary. And this brings the workers' compensation legislation in line with the CTP scheme. Now, at first glance, this may seem like a small and even semantic change, but the reality is it introduces a much higher threshold for treatment approval. Case managers are now required to apply two separate tests. First, is the treatment reasonable? And then, is it necessary? With both conditions needing to be met, we expect that some treatments currently being approved may no longer meet the new criteria. And this could particularly affect treatments that are high in cost, experimental in nature, or supported by only limited clinical evidence. Some examples might be spinal fusions, spinal cord stimulators, medicinal cannabis as MPIC. And if we refer to the CTP case law, we can also find examples where even imaging has been declined and that decision upheld as it didn't meet the test of both reasonable and necessary. So while the wording may seem minor, the outcome for injured workers, employers, treatment providers and overall scheme costs could be significant. Another change that applies to all claims, not just psychological injury ones, is that in future, workers will be required only to attend one assessment for a whole person impairment assessment. Today, a worker must attend at least two and sometimes three separate assessments with different assessors, each time requiring them to retell their story. The process can be distressing for workers and it does cause significant delays in decision making. Under this new legislation, the worker and the insurer will need to agree on who the assessor will be. And if they can't, CIRA will appoint an assessor for them. A further principal assessment may be conducted under special circumstances, including where there is a deterioration in the worker's condition. And where we have a disagreement between the worker and insurer, this becomes a medical dispute and the matter will be referred to the Personal Injury Commission. Our experience today is that 40% of permanent impairment claims are resolved at least one band lower than claimed. And while this change seems quite positive from a worker's perspective, it's one that we'll watch and monitor with some interest. So now we move on to the most significant changes, and that's those relating to psychological injury claims. This bill introduces new definitions for psychological injury claims, which will provide better clarity and certainty as to what psychological injuries are compensable under the scheme. For psychological claims, the injury must have been caused by a relevant event. And that includes things such as an act of violence or threatened violence, indictable criminal conduct, witnessing a traumatic event, vicarious trauma, sexual or racial harassment, bullying, and excessive work demands. And in addition, there must be a real and direct connection between the event and the worker's employment, and employment must be the main contributing factor to the injury. But after that, when we have a relevant event such as bullying, harassment, and excessive work demand, these things are also defined as relevant conduct, and this will then require a new process to be applied for liability determination, and Matt will talk you through that shortly. To determine whether there is relevant conduct that amounts to a relevant event, an objective test is applied. The question to be considered is whether a reasonable person, having regard to all of the circumstances, would have anticipated that another person would be offended, insulted, humiliated, or intimidated by the conduct. This is a much clearer test than what we've had previously in the legislation. We could also use a finding by the Industrial Relations Commission as evidence that relevant conduct had occurred. And this may mean that we do see an increase in the number of matters that are being referred to the Industrial Relations Commission, which is something that will interest all employers.
As Katie mentioned, where the injury is caused by relevant conduct, we'll see a new process for determining liability. Again, this change has a sense of back to the future about it. Prior to the introduction of provisional liability with the 2001 amendments that commenced from the 1st of January 02, an insurer had 42 days to determine liability for each and every claim. The introduction of provisional liability increased this time frame to up to 12 weeks, if I speak simply on that matter. Where a claim results from relevant conduct, bullying, harassment, excessive work demand, an insurer will have 42 days to determine liability. Determining liability for this type of a claim really means that a reasonable person would have had the same reaction to the events, which would remove the concepts of perception and eggshell skull that I referred to earlier. This blends with provisional liability. So during that 6-week liability determination period, a worker will be able to receive interim weekly benefits at 75% of their PIAWE, and interim medical expenses up to a set limit of $7,500. So what that does is it's reduced the entitlement to weekly benefits by 20% from the 95%, and it's reduced the cap for medical expenses during a provisional liability period from $10,000 to $7,500. Now, if a claim is accepted, the insurer will be required to pay the difference between what's been paid to date and what they'd be entitled to for an accepted claim, being that 95% of their PIAWE in that first 13 weeks. But the devil for this change is really going to be in the detail. What does a worker need to submit to bring a claim for relevant conduct? And we're really going to need to wait for the regulation from CIRA to understand the claim-making requirements that will be imposed upon a worker.
The bill also provides stronger defences for an employer, particularly where there has been reasonable management action. Those of you on the call may be familiar with Section 11A. It is arguably one of the more contentious provisions of the current legislation. When it was first introduced, the intent was clear: to exclude workers' compensation claims that arise as a result of an employer's reasonable management action. In practice, this was intended to protect employers making fair decisions about things like performance management, disciplinary action, or organisational change. However, over time, case law has significantly narrowed the scope of this clause. Today, in practicality, it's very difficult for us to decline liability under Section 11A. And one of the main reasons of that is that the worker's perception of events must be taken into account. So the bill today introduces Section 8F to redefine what constitutes reasonable management action. This new section provides a non-exhaustive list of employer actions and communications that constitute reasonable management action, and specifies that the action must be taken in a reasonable way and be reasonable in all of the circumstances. And then we have an amendment to Section 11A, which specifies that a psychological injury will not be compensable if it arises from reasonable management action or from the worker's expectation or perception of a reasonable management action. And now this change applies to both primary and secondary psychological injuries. In short, these new definitions should serve to strengthen a defence under Section 11A, protecting employers from claims arising purely out of the normal, fair and necessary functions of managing a workplace.
The next change is to then reduce the, and this was one of the most contentious as it was debated through the upper house, was to reduce the cap for weekly benefits for a worker who with a primary psychological injury from 260 weeks with less than 21% WPI or whole person impairment to 130 weeks. That is a simple mechanical change to the Act, but it now creates brings forward a situation where a worker who has greater than 15% whole person impairment will still retain access to work injury damages to effectively resolve the claim, as we have with Section 39 today. What will be more interesting will be how quickly a worker can have their whole person impairment determined, whether 130 weeks is long enough to determine that they've reached maximum medical improvement from a primary psychological injury. The next change is results following on from that. So, and this is where I realise exactly how complicated workers' compensation framework is for workers, for employers, and for our case managers. We now have a third tier of medical benefit cessation. Simply speaking, again, a worker has an entitlement to medical benefits for a period of time after their weekly benefits cease. For a whole person impairment for a physical injury of 0 to 10, they're entitled to medical benefits for 2 years after the last date of weekly benefits paid. If their whole person impairment is 11 to 20, they're entitled to medical benefits for 5 years after that last date of medical benefit. And if their whole person impairment is 21% or greater, they have a entitlement until for as long as it's compensable from there. Now, what this will do is, for a primary psychological injury, introduce a third tier of medical benefit cessation, where if a whole person impairment is less than 21 from a primary psychological injury, they will only have an entitlement to medical benefits for 1 year following that cessation of weekly benefits. So when combined with the earlier change to cap weekly benefits to 130 weeks, this will only see that entitlement go to 182 weeks post date of injury for a primary psychological injury. Perhaps the one change that was not approved within the first bill, which has been is a key part of the second bill, is that the government had proposed to increase the whole person impairment threshold from 15% for lump sum and common law damages, and from 21% for ongoing weekly benefits, to bring all three of those in line at 31% whole person impairment. A lot of the commentary by the opposition and the Greens through the debate was about how small the number of workers would be who'd retain an entitlement with such a threshold for whole person impairment. The government has, in bringing the second bill, the Premier spoke on Tuesday that without an amendment to this threshold, employers would face a significant increase in premium, with 17% being quoted for financial year 27 for renewals 30 June next year onwards, is what I refer to with financial year 27. The second bill has got the compromises from Alex Greenwich, the independent member for Sydney. What has been proposed in this second bill, which will be debated by the upper house next week, is a compromise position of 25% to commence from the 1st of July. 25% whole person impairment, not premium increase. Important to make that point. From the 1st of July, injuries resulting from the 1st of July 2026, and then increasing over the 3 years to the 1st of July 2028, where it would reach its final resting place at 28% whole person impairment versus the 31% proposed by government in the first bill. And also to have the state's chief psychiatrist review and design a new model for assessing permanent impairment for primary psychological injuries. Perhaps the biggest challenge we see with the assessment process for a primary psychological injury is a lot of it is based on evidence as delivered from the worker as a witness to a psychiatrist, be it their own psychiatrist through their solicitor, through the psychiatrist that we have undertaken assessment, or indeed when the matter does go on occasions to the Personal Injury Commission, to that third assessor. It's lacking that level of objectivity in terms of a contemporaneous file review versus the answers to questions given about activities of daily living in evidence. So it'll be nice to see how that gets redesigned to be fairer for all involved.
There you go. That's a very broad overview of the material amendments to the legislation from the first bill that is passed. So now we wait for the government to determine when the amended bill will be effective. And what we may find is that different amendments have different commencement dates. As Matt just mentioned, late this week, the second bill with amendments to that WPI threshold for lump sum compensation and common law damages was passed by the Legislative Assembly, and it now needs to be debated by the Legislative Council. And similarly, if that is passed there, we will then wait also for confirmation on its effective date. But the legislative changes are just the first step. CIRA, as the regulator, will then need to make changes to the regulations and standards of practice, and these changes must then be adopted by iCare and other insurers. I'm watching a lot of the questions that are coming in, and a lot of the questions are actually going to be answered by the regulations as opposed to the bill that we have in front of us now. Finally, for us as a claims service provider, we're preparing for the operational implementation of these changes. And for us at EML, what that means is that we are focusing first and foremost on understanding the resource impacts of the change and ensuring that we have specialists with the right capability and training to apply the new legislation. We're fortunate to have gone through a similar process of reform such as this recently and over the past 2 years in Victoria, and we'll be relying quite heavily on our colleagues there to learn from them and what they experienced through the last 2 years. We are developing comprehensive training for all of our case managers and working through what adjustments are required to the claims management systems and processes we work with. What we know is really important is that we get this right from day one, so that we're making decisions in accordance with the legislation and not inadvertently setting a precedent that will water down the provisions, something we're very focused on here at EML. We're also focused on keeping our customers informed through forums such as this. And we'll be using our mutual benefits program, through which we reinvest our profit into products and services for the benefit of our customers, to develop resources, tools and training that you will be able to access to help you navigate this change in your own workplaces. We'll keep you informed as these resources are made available. For you as an employer, there are a number of things that you should be prepared for. Firstly, our experience from other reforms suggests that we should expect to see a slight increase in the volume of psychological injury claims that are lodged between now and the effective date of the legislation. Indeed, we've observed those sorts of increases even since March, when the potential reforms were first announced. Next, moving forward, these reforms mean that Some issues in the workplaces, such as interpersonal conflict, that previously evolved into workers' compensation claims, they'll no longer be compensable. And what that means is that employers are going to need to rethink their own HR and IR processes that they might need to help support these workers as they work through those issues in the workplace. And things you might want to consider are, adopting mediation and conflict resolution practices into your workplaces. And they're things that we are now adopting in our claims management processes, and we're finding are having a very positive impact on the outcomes we can achieve in those situations. For employers, this is also the right time to start reviewing and updating your WHS practices, policies and training. The psychosocial risk regulations in New South Wales mean that mental health hazards in the workplace are just as important as the physical ones, and employers are required to address those hazards proactively to reduce the risk of injury. They should be thinking about things such as role clarity, change communication and practices to encourage a healthy work-life balance. The legislative reforms are likely to prompt increased pressure and focus on this and on employers, ensuring that they're taking preventative measures. So make sure you're ahead of the curve on that one. And lastly, it's really important that as employers, we all understand the new legislation so that we can best inform and support workers in the unfortunate event that they do sustain a workplace injury. So we've received some questions through the chat. We will now do our best to address those and answer them. And as we said at the start, any that we can't answer today, either because we don't yet have the information, we will take them on notice and try to get those answers back to you shortly. So the first question, Matt, is will the 2-week excess apply on all claims or just those that have immediate time loss?
Currently, it is not clear. However, again, looking to pre-2006, the excess only applied on weekly benefits, not to the medical benefits or other aspects of a claim from there. So if a claim was to only have in pre-2006 language, if a claim only lost 3 days, the excess would only be 3 days. Or if there was only 500. But when that was $500, if there was only $400 lost, the excess was only the $400 of weekly benefits from there. So if I look to the past, I would anticipate something similar in the future.
Thanks, Matt. Oh, sorry.
I think I'll ask you one, Katie. Will the list of new definitions and actions under reasonable management action be made available?
Yes, is the answer. So in the bill, there is a section 8F2, which provides 15 examples of what is reasonable management action. And that includes things such as appraisal of or feedback about the worker's performance, counselling, demotion, redeployment or retrenchment, disciplinary action, dismissal, promotions, including where the worker is unsuccessful in promotion, provision of leave absences. There's a lot in there. What we will do when we provide the recording of today and the next update, we'll share a link specifically to this section and outline all of the conditions that are defined as reasonable management action. But it is quite clear. Okay, Matt, will these changes apply to current claims or only future claims?
It's an answer in two parts. Some will apply to current and some will apply to all claims. And some depends on what the actual definition of a claim means. Obviously, we talk about a claim, and a lot of what we've spoken about today, a claim is a worker putting their hand up and saying that they've had a workplace injury. The new definitions of reasonable management action, relevant conduct, relevant event, that will only apply to new claims. Those existing claims will continue to operate. Where we have spoken about the impact of whole person impairment, that depends on whether or not a worker has brought their whole person impairment claim by a date. And that date needs to be determined by government in terms of the implementation. Where we spoke about reasonable and necessary versus reasonably necessary, where we talk about a claim there, a claim is asking for a treatment, asking for a reimbursement. Once we have the commencement date, any request for a treatment that was received prior to that date will be assessed against reasonably necessary, irrespective of date of the injury and its claim, and a request for treatment or reimbursement received the day that commences will be assessed against the new definition of reasonable and necessary. From our perspective, that will provide this weird 20-day period where our team of case managers will be assessing things against both definitions, depending on when it was received. And I think there'll be a small number of matters that then end up in the Personal Injury Commission that will be assessed against the former definition, whilst that gets grandfathered out, noting one of the other questions that we've put through. So an element of application to claims that exist, but some of it only applying to new claims.
Thanks, Matt. I'm going to ask you this one because I think you are best placed to answer this one. There's a question that's come in asking, and so a lot of this is not actually related to the legislation, but from a philosophical position. Are we going to see that there are more psychologists who are available to determine claims? As what we see today is it could take up to 3 months for the employee to be assessed. Now, I think we've got a change coming to what that assessment looks like for a liability determination that may have a positive impact on this. Do you have a view, Matt?
Yeah, if I go back to the type of psychological injuries that we're assessing at the moment and those 3 decisions that occurred in the last decade, it almost required every claim as part of its determination to be assessed by a psychologist or psychiatrist from a medical standpoint. This 6-week period is purely to determine the factual circumstances, whether a reasonable person would have had that same reaction that then resulted in a medical illness or a psychological illness from those events. So it'll, again, I've used Back to the Future, I think 3 times now, Katie, a return to those 3 decisions where it's accepted that a person does have a psychological condition, but was that caused by the reasonable actions, the relevant event or relevant conduct by an employer or another member of the team? I think with our Recovery Pathways program, we've seen a vast number of interpersonal conflict claims actually exist from team member to team member, as opposed to it involving leadership or management within an organisation.
So I guess maybe another way of saying it is, while we're not looking, it would be great if we could have more psychologists and psychiatrists within the scheme and within the system more generally. What we think is that these changes will actually reduce some of the demands on those services for a liability determination, which should then have the benefit and that flow-on impact with our other claims. It should help to bring those timelines down for an assessment if we're not sending every single claim through that process. Okay, and I think we've got time maybe just for one more, and you're doing such a good job, Matt. I'm going to keep asking the questions. There's a couple of questions here about what happens in the event that the psychological claim is not accepted. We've paid 75% of their PIAWE. Is there any indication that this will then be repaid? And a similar question is then, what will be the impact on an employer's premium if the claim is not accepted after that time?
They're not questions that EML can answer. As a claim service provider, we manage a claim, whereas from iCare manage the premium calculation formula. So that question would be best directed towards iCare. Once we understand more, this is only new in terms of they're starting to understand. They will need to file their market premium practice guidelines with CIRA for FY27, and I think that would be the appropriate place to ask, and probably guessing at time, March would be the time to ask from there, as it would apply to those new claims and that next premium year.
Fantastic. Thanks, Matt. Okay, I think we are almost at time, so we might hold it there. We will capture all of the rest of the questions, as I've said. We'll do our best to answer what we can through subsequent communications with you. I hope that you've all found today's session informative. This is a really this is a big change that our industry will face over the next year or so, and we are looking forward to working with you through those changes and ensuring that we get it right for the benefit of the employers in the scheme, the workers that we support, and the scheme overall. Thank you so much for your time, and we look forward to seeing you at our next event.
Thank you.